Well, from property rights to water regulations, there are a lot of legal factors impacting farmers and ranchers on a daily basis. Today, we're going to look at a few recent court developments and the lessons that were learned for producers. Well, the guy that breaks it down for us, Roger McEowen with the Washburn School of Law, with all the details. Roger, thank you so much. So let's go ahead and get to this. A lot of information here. The first case that we're going to be talking about involves a cranberry bog or cranberry bogs and the Clean Water Act. Talk about this case.
Yeah, good to be with you, Suzanne. This is an important one, not just for cranberry production, but I think also for rice production and potentially for crop irrigation agriculture, because what this involves is an aspect of the Clean Water Act that, of course, if you are subject to the Clean Water Act, you have to have a discharge permit to discharge a pollutant into the navigable waters of the United States. And pollutant is defined very broadly under the Clean Water Act and includes such things as sediment itself, as well as phosphorus and other things that is important to us in producing crops and producing food and fiber in this country. Well, what happened in this case involves a challenge to an exemption that agriculture has known as the Irrigation Return Flow Exemption. If you are an irrigator, your return flows from that irrigation in agriculture is not subject to the permit requirement under the Clean Water Act, because you're not directly discharging into a federally covered waterway. WOTUS, for instance, is what I'm referring to. The water is draining through the soil, and it's not a point discharge point into the navigable waters. What the claim here is in this case that's been filed in the Federal District Court for Western District of Wisconsin is that, well, cranberry production should not get that exemption because they're not irrigating. They're draining those bogs that are used in a production process. And because there was a ditch that was nearby that fed into a channel that fed into a navigable water of the United States, they needed to get a permit requirement under the Clean Water Act. So they can't, since they're not irrigating, the claim is they can't use that exemption. So we'll have to see how this goes. What the trial court says, this has just recently been filed, so it's got a long way to go. But potentially that could have an impact, depending on what the courts say is the scope of the return flow exemption for irrigated agriculture, could have an impact on crop agriculture down the line.
Very interesting. Obviously, a case you're going to be following, and hopefully let us know. We'll catch it back on that one. Another case that we're going to be talking about, implications in regards to property rights. Give us a recap on this.
Well, this is a case out of Montana. This particularly would affect the viewers in the western part of the United States. There's a lot of the western land is owned by the federal government and controlled by the federal government. You got the forest system out there, the national parks, so forth and so on. And we had two landowners in western Montana that the prior owner had granted an easement to the federal government across their ranch land to get to a Forest Service property from a public road for timber harvesters. Everything went well in terms of that ingress-egress easement for 45 years. Then one day the government stuck up a sign that said this is a public road. Well, the landowners then sued under the Quiet Title Act, and the government responded saying, well, you sued too late. You waited more than 12 years from the time we posted that sign. You're barred. This went all the way to the U.S. Supreme Court, and the Supreme Court said that 12-year time limitation is not a jurisdictional limitation. It's a process, a procedural limitation. So they're going to get their day in court. And that really, I think, has a big impact on the potential protection of private property rights, particularly in the western part of the United States.
Absolutely. You and I have spoken about that before, where those lines can really become blurred. You know, there's so much information. We could spend hours on this, unfortunately out of time. But Roger, always great information and so many lessons learned that our producers can take with them. Roger McEowen with the Washburn School of Law, always a pleasure.